morning, Facebookers.
Continue on East Prima Vista Boulevard for 1.5 miles.
So, this morning I want to talk to you guys about that trust. That cesti trust. The birth certificate, the Social Security account. But mainly I want to talk to you, and I'm just going to do a quick run through on it. And I want you to go study these words. I want you to go study the IRS publication 1212, amongst other documents. I want you to study rights, titles, interest, dividends, derivatives, debentures, hediments, general tangibles, general intangibles, chattels, securities, annuities, bonds, trust residue, trust residual, rents, profits, proceeds, and assets. Double bookkeeping entry ledgers, off-sheet balance accounts, T-ledgers. These are all very, very, very important for you to comprehend what they are, because it pertains to you as the beneficiary. By proxy, they have you coming in under the cesti trust as a trustee by proxy. And when you fill that role, you become the surety, which there's nothing wrong with being the surety so long as your right of subrogation is upheld. But it's very slim to none that your right of subrogation is actually upheld, you know. And I know that this works because I've come in on behalf of another principal before, acting as surety, just needing my right to be availed, to be assured that subrogation occurs and that I have a full accounting of what's being done. Because I'm basically coming in as an insurance agency, right? Or an insurance agent, unidentified, unregistered insurance agency. I'm coming in as surety on behalf of somebody else. And I watched the alleged judge, which is really an administrator administrating the cesti trust, turn 3 shades of peaked white, because she knew that I knew that it was about the banking and the bookkeeping entries and ledger system. She knew that the real trustees, including herself, as well as the prosecuting attorney, were on the hook for securities fraud, tax evasion. So again, it's about the rights, titles, interest, dividends, derivatives, debentures, hediments, general intangibles, general tangibles, annuities, trust residuals, trust residue, assets, baggage, effects, rents, profits, proceeds, ladies and gentlemen, that you're entitled to as a beneficiary and as a entitlement holder. What proof do you have that you're an entitlement holder? Well, you hold the receipt. That birth certificate is evidence of a very, very large debt owed to you as the beneficiary. There's a maxim of law. A small debt makes a debtor. A large debt makes an enemy. Okay? And that's why the people in government consider you an enemy belligerent combatant of the United States. You haven't forgiven them of their trespass. You haven't forgiven them of their debt that is owed to you. And it's real simple. You know, when we read about the Articles of Surrender, what Japan wrote for an Articles of Surrender to the United States to end the war, right? There's a rule in banking. In banking, the bankers fund both sides of the war. The victor of the war carries the primary active degree of fault and obligation to pay the loser's debt. So surrender. Invoke Title 18, subsection 8, Public Law 7310, House Joint Resolution 192, and do Articles of Surrender under the Law of Nation 192. Law of Nation 192 is one paragraph, ladies and gentlemen. And comprehending how the banking system works, if you surrender, guess who's primarily liable by an active degree of fault to make sure all debts are paid? That's right, baby. The United States. Which really, they're just administering your trust, accessing your estate, accessing the Social Security account for which you're the beneficiary of. It's not Federal Reserve notes that are created by accessing this account. It's more permissible units or credits on account. It's not actually physically tangible paper, per se. Ladies and gentlemen, the Federal Reserve is privately owned. It issues its own script that is governed by the DoD, Department of Defense. Federal Reserve notes are only supposed to be used, according to their banking manual, for bank-to-bank transactions. And those Federal Reserve notes are instruments of debt. And you cannot pay a debt with a debt. Franklin Delano Roosevelt addressed that in his inaugural speech. Go look it up. So if they have the ability to create credits on account out of thin air, guess what? So do you. I want you to go look up letters of credit, bills of exchange, international bills of exchange, promissory notes. I want you to go look up the Canadian Coinage Act, where it states in there that it must be given for a patent right. I know what you guys are thinking. Well, what does Canada have to do with us? Look, the monetary system is the same across the board in all nations. It has to be, or it wouldn't function like a well-oiled machine. It's the same. Clean across the board. With the exception of the banking system that China and a couple other countries are involved in. But you got to have a yin and a yang, or you don't have a complete system. You can't have an ecosystem that doesn't have wind, water, fire, and ice. It just doesn't work. Without one of the elements, it falls apart. So you always have to have a yin and a yang. So there's two competing banking systems in the world. You got the IMF, and I can't remember the name of the other one. You'll have to go look it up. But China uses the other one. Along with a handful of other countries. So again, I'm going to repeat this really slow. If you want to understand and comprehend what's really going on. You got the Cesti Act of 1666. You've got the Unum Sanctum of 1302. You've got Justinian back in 524, creating the nom de guerre, the name of war, the all capitalized spellings, which in the U.S. Code clearly articulates that anything in all caps is either a corporation or a trust, a limited liability corporation or a partnership. Okay? That's what the all caps identifies. According to the Chicago Styles Manual, there is no written rule in grammar for all capital letters. So it's something that they have constructed in order to symbolize the creation of a trust. Let's talk about trust relationship for just a second. A trust can manifest without anybody being consciously aware that a trust exists. For example, how many of you realize that when you take your offspring to a public school, that is a trust relationship. How many of you comprehend that a trust manifests between you and your esposa when you get a joint bank account? Okay? How many of you understand that going to a doctor, which is a title of nobility run by the military DOD system, doctor is actually a title of nobility? How many of you realize that when you go to a doctor, that is a trust relationship? Very imperative that you guys start to comprehend what's going on in order to change it. And to go to peace. There's no need to be at war with the system, because the only reason a man would be at war with this system is because he doesn't understand. He does not comprehend what it is. The court systems create resulting and constructive trust. They actually create constructive trust. And what they're doing is they're passing the liability onto you because you don't know who you are. If they can presume and assume you to be the trustee, well, you can declare to be the beneficiary. Now, I don't like the word declare because declare is an active term of war. I'd rather be an asservant, okay? Asservating the fact that I am the beneficiary. Terms of peace are better than terms of war if you're really going to peace. The IRS is your best friend. They're the ones for keeping the books and the accounting. I was really impressed with Chris Hauser lately. I would implore you all to go look him up on YouTube. Christopher Hauser. Very impressed with his work. Trust law should be something that you guys really start to focus on. Hardcore. Before you get into the banking aspect of it, Trust 101 is mandatory. Okay? How many parties are to a trust? And granted, you could be the grantor, you could be the grantor settler. Just because you're the grantor doesn't mean you're the settler. The settler can be independent of the grantor. You got the beneficiary, of course. You've got the trustee. When legal and equitable title are in the same person, the doctrine of merger applies, and you become the grantee absolute, which collapses the trust. But you better have a place. You better have another trust set up, because when you collapse a trust, that property, the assets of the trust, must transfer to something. Remember, NREM deals with things. NREM proceedings, and all your court systems are NREM proceedings. They deal with things, not man. Okay? I want you to remember this. Show of cause why my rights shall be commingled with that of enemy belligerent combatants of the United States, or be it resolved, this case is now sealed and ex parte, because it's a matter of trust. All right? Do you disclaim the trust? Does anybody in here disclaim the trust? Or, because if you do not disclaim the trust, then be it resolved, it is a trust, and it will be treated as a trust. Because it deals with property. And rights are property, and property are rights, and without one, you can't have the other. They're not necessarily synonymous, but again, without one, you can't have the other. And being that this deals with property, the only way to properly address this subject matter is private, in camera, in chambers. It's by special private trust deposit. In camera, in chambers. So anyway, these are just a few things that I wanted to run through this morning. Rights, titles, interest, dividends, derivatives, debentures, hediments, general tangibles, general intangibles, annuities, trust residual, trust residue, assets, rents, profits, proceeds, baggage and effects, entitlement holder, beneficiary. These are very important. Securities. Okay? Bonds. Everything you affix your signature to, your sign of nature, qualify it as the beneficiary. Know that you're not abandoning your securities, okay? You're a non-disclosed third-party beneficiary in a lot of situations, if not the non-disclosed primary beneficiary, okay? I hope you guys have a wonderful, blessed day. We'll talk to you soon. Just a short little video to bring you up to speed. Everything that I am talking about is very essential to comprehend. It's taken me a long time to get here, and the great news is, if I can do it, you can too. All right? Also want to talk a little bit about power of attorney. The power of attorney is granted by the grantor to the grantee, all right? To the beneficiary. And that grantor made a special trust deposit and got nothing in return for her contribution, for her deposit, which was the application. The original instrument was not the birth certificate, ladies and gentlemen. It was the special trust deposit made with the original application, the original instrument with wet ink signature, to the state registrar through the hospital. All right? And it was never her intent to bequeath your estate to the state. And at the age of 18, you were supposed to come forward, if you read the Cesti KV Act of 1666, and let the state registrar, the attorney general, the governor, the secretary of state, the IRS, the IMF, the Social Security Administration know that you're alive, that you're well, and that you are the beneficiary, the intended beneficiary of the special trust deposit, because that was the intent of the testator. That was the intent of the grantor, ladies and gentlemen. And you got to establish that. Now, after the age of 25, they presume and assume that you have abandoned the estate, and now they're administering it on your behalf. The lawyer's coming in on behalf of the beneficiary saying, Your Honor, nobody's come forward to claim this estate, and we don't know this imposter over here. We presume and assume that he's an imposter, and in order to benefit the beneficiary and to protect the assets of the trust, the prosecuting attorney is coming in on behalf of the beneficiary, the unknown, undisclosed beneficiary, because nobody has proven to this point that they are the intended beneficiary. How would we prove that we're the intended beneficiary, ladies and gentlemen? Well, if your mother is still alive, you would have her write a simple power of attorney, her intent when signing the application for the birth certificate. Okay, what was her intent? That she got nothing of value in return. She created something of great value by filling out that application, okay, and making that special trust deposit. But she got nothing of value in return, which creates a trust. Without an estate, there can be no trust. And the estate is manifested into existence by that first document after your being brought into this world at your place of nativity. Real simple. Trusts are birthed. Corporations are birthed. Ships are birthed. Think about this a little bit. So, Henry R. Gibson, Palmery, Joseph Story. I'm going to tell you right now, if you really want to understand trust, Henry R. Gibson explains it in layman's terms. It's so brilliant. So with that said, I have some things to do today. I love you guys. I hope this helps you out tremendously. Rights, titles, interest, dividends, derivatives, debentures, hediments, general tangibles, general intangibles, annuities, securities, bonds, trust residual, trust residue, assets, baggage, rents, profits, proceeds, effects, ladies and gentlemen. You are an entitlement holder and a beneficiary, ladies and gentlemen. And if you do a merger under the doctrine of merger, merging equitable and legal title, which I, through my research, don't think I want to do. Because once you do that, now you're losing your trustees. I want you to study the Power of Appointment Act of 1951 and realize the ramifications and the benefits of the Power of Appointment Act of 1951. I want you to go study the Form 56 and its instructions. I want you to go study the Form 56F and its instructions. Okay? The 1099 OIDs, the 1099 NIVs, the 1099 A's, the 1099 B's, 1099 C's. If you comprehend this, the IRS, look, in 1871, under the Reconstruction Act, Abraham Lincoln put everything in the care and custody as the alien property custodian holder for the American people in trust with the IRS. All right? Yep. So, with that said, I love you guys. I hope this helps you in your journey. I don't have all the answers, but I've been at this a very, very long time, and thanks to all of you supporting me and helping me, I am able to bring this information to you. Thanks to Mr. Anonymous and so many other people out there that have helped provide proper guidance, and believe it or not, some administrators from the bench that have bestowed information upon me to help me on my journey. Never quite giving me the answer, but allowing me, guiding me in the right direction, the literature to read, to ascend to the mind, so that if tested by the gatekeepers, I can walk through that narrow passage. So, with that said, I love you guys. Have a great day, and we'll talk to you soon.